XRP big win in SEC case after Judge Netburn denies SEC access to Ripple legal memos. Ripple Labs, the organization behind XRP, has scored another huge win against the United States Securities and Exchange Commission as the fight in court proceeds. In a new notice from the United States District Court, the update shows that Judge Netburn has denied the SEC admittance to Ripple Labs correspondence notices. The archive expresses that the SEC had been looking for a request to get all interchanges establishing, communicating, or talking about any legitimate exhortation Ripple looked for or got with respect to whether its offers and deals of XRP were or would be dependent upon government protections laws. Hello everyone, welcome to Future Crypto. Here you'll be informed about the daily crypto news along with the price predictions and updates. In today's video, we'll update you about Ripple's recent big win in the SEC case as the judge denied the SEC access to Ripple's legal memos, issues raised against the judgment, and what if Ripple loses the lawsuit. Another win for XRP in SEC versus Ripple case. In the claim brought by the U.S. SEC against Ripple Labs, CEO Brad Garlinghouse and prime supporter Christian Larson over the offer of XRP tokens, the court has denied the SEC's solicitation to get individual monetary records of the litigants that are irrelevant to XRP. Magistrate Judge Sarah Netburn endorsed the request on Friday. The SEC has served the individual litigants with requests for production looking for their own monetary records over an 8-year time span, the request clarifies. It adds that the Commission has additionally given outsider summons to a few monetary organizations at which the individual respondents look after accounts looking for comparable records. The order notes, Garlinghouse and Larson move for a defensive order to keep away from their disclosure commitment and to subdue the summons served upon SVP Financial Group, First Republic Bank, the Federal Reserve Bank of New York, Silver Lake Bank, Silvergate Bank, and Citibank N.A. The movement is allowed. Referring to Section 5 of the Securities Act, which subtleties that all guarantors should enlist non-excluded protections with the SEC, the order states, the court is not convinced that the personal banking records would show or even could show what the SEC claims they would, individual violations of Section 5. The appointed authority, moreover, has tracked down that the SEC has not introduced any proof that singular respondents have covered up exchanges or that the reports produced support any derivation of covered up exchanges. Besides, the adjudicator clarified that the movement for a defensive request by Garlinghouse and Larson is conceded in light of the fact that the court tracks down that the SEC's solicitations for the individual litigants' very own monetary records, aside from those records of XRP exchanges that are as of now guaranteed, are not applicable or corresponding to the requirements of the case. The judge further ruled, the SEC shall withdraw its requests for production seeking the individual defendant's personal financial records and withdraw its third-party subpoenas seeking the same. On the off chance that, as disclosure advances, the SEC reveals proof that the individual litigants have not been approaching with records of their XRP exchanges, it might give such proof to the court and restore its application, the request finishes up. Ripple, as of late, one revelation from the SEC and the Commission has been requested to create inside records on Bitcoin, Ether, and XRP. In the meantime, a request has been begun asking SEC's new director to drop the Ripple claim and end the conflict on XRP. Issues raised against the judgment. In the memo, Judge Netburn added a few focuses to the justification denying the SEC. These included lawyer-customer advantage. Netburn repeated that lawyer-customer advantage ought to be rigorously restricted to the tightest potential cutoff points reliable with the rationale of its standard. Another issue raised against the SEC's demand is lawyer-customer advantage. The notice repeats that the gatherings don't question that the data the SEC looks for falls under the advantage. Besides, Ripple Labs guarantees that its reasonable notification protection was that there was an absence of clearness and reasonable notification in regards to defendants' commitments under the law. Ripple Labs additionally expressed that the long-term delay in seeking after-authorization activity against the organization following more than 200 trade postings and billions of dollars in XRP deals exchanges is another worry. Ultimately, Ripple Labs additionally clarified that a specific trade had sought guidance already in regards to XRP being viewed as a security prior to posting. The SEC did not express that it believed XRP to be a security and said the trade recorded the digital currency. Taking up the fair notice battle further. One of the central points of contention in the SEC versus Ripple fight has been the issuance of reasonable notification. Ripple asserts that the SEC has never given a reasonable notification whether if the blockchain startup was disregarding any protections laws for 8 long years. Simultaneously, FinCEN and the U.S. Equity Department had proclaimed XRP a convertible virtual money. Ripple is presently attempting to move this case with an emphasis on SEC's inactions and an unexpected change in the perspective. In any case, Judge Netburn noticed that she is not taking any position if Ripple's protection is plainly recognizable. The adjudicator said, "I reach only the limited question of whether Ripple put its subjective state of mind or advice of counsel at issue, merely by raising the defense, thus waiving its privilege. I conclude it did not. Accordingly, the SEC's motion is denied. If at some later date Ripple raises its good faith beliefs or relies upon its privileged communications in support of its fair notice defense, the plaintiff may renew its application to the court." XRP jumps 13%, approaching $1 as Ripple stops SEC from accessing legal records. Although the by and large crypto market is by all accounts under descending pressing factor, Ripple's local crypto XRP has shot 13.53%, taking an action to $1. At press time, XRP is exchanging at a cost of 99 cents with a market cap of $44.21 billion. This most recent value rally in XRP comes as Ripple enlists another miniature success in its fight against the U.S. Protections and Exchange Commission, SEC. Ripple has figured out how to prevent the SEC from getting to any lawful records of the organization as mentioned by the controller. What if Ripple loses the lawsuit? Nobody knows other than them, yet moving to a more amicable ward is well on the way to serve the interests of XRP holders in such a situation. Brad Garlinghouse, Chief Executive Officer at Ripple Labs, has, as of late, told that there is a misconception of how these advances can be applied. In the United States, there's been an absence of administrative clearness. Different nations, G20 markets, they have contributed the time and energy either through enactment or rulemaking to give that clearness and sureness which permits financial backers to partake, business people to construct. XRP is an open-source innovation similar to Bitcoin. However, the SEC is making the attestation that these are venture contracts. That Ripple deals of XRP to our clients is really a speculation contract. That is not accurate. On the off chance that you purchase XRP, you do not have responsibility for, and unexpectedly, you have XRP proprietors who have attempted to sue the SEC for bringing the case. While administrative vulnerability wins in the United States until further notice, the IRS needs to get paid. This has sent nerves inside the crypto space, and of course, inquiries regarding security and protection emerge. Meanwhile, institutional interest in computerized resources is breaking news. A new exploration report by Goldman Sachs said Bitcoin is presently viewed as an investable resource. eToro, which was one of the first to offer admittance to crypto markets since 2013 and has now 20 million enlisted clients, has added Aave, Compound, Yearn.finance, and Decentraland to a sum of 23 cryptos accessible for exchanging. So guys, this is it for today's video. I hope it could be of a big help to you. Let us know in the comments. What's your opinion on the judge deciding for Ripple against the SEC over close-to-home monetary records disconnected to XRP? Tell us in the comments section below. Don't forget to click the bell icon, and thank you for watching.